Good afternoon, everyone, and thank you for joining us today for the third part of our four-part legal clinic, Mitigation Risk in Cook County Contracting. Today, we have our presenter, Lema Khorshid, who will be joining us in just a second. Before we get started, I'd like to give you a few housekeeping items. First, we have all cameras and microphones disabled so as not to distract the presenter. At the end of the webinar, we will open it up for Q&A to the audience, and everyone on the call today will receive a copy of the deck. Now, without further delay, please help me welcome our presenter to the stage, Lema Khorshid, representing Fuqsa Khorshid LLC. Lema, take it away.
Can everyone hear me?
Yes, we can hear you.
Okay, great. So today's seminar is about mitigating risk in county contracting. Next slide, please. So again, thanks everyone for joining. I'm a practicing attorney. I've had over 22 years of experience focused on representing mid-sized, closely held businesses. And I've done a lot of contract review and compliance as well as dispute resolution in county contracting. I've also represented business owners like yourself in handling some of their employment and intellectual property matters, as well as some of their litigation matters. So this seminar is premised on some tips that I have, I kind of have cultivated over the years and a way and perspective that I have on counseling my business owner clients. So it's wonderful to have everybody. And with no further ado, here's the outline for today's seminar. Next slide. So essentially, we're going to go over a couple of things today. One of them is an overview of confidential information, understanding some of the intellectual property rights in county contracting, and then, how to protect intellectual property and confidential information, and then how to comply with operational and risk management, as well as some restrictive covenants that protect some of your business relationships, and then reducing your exposure should a dispute arise between a prime and a subcontractor, as well as dispute resolution and navigating disputes with the county. So with no further ado, next slide, please. Next slide. So the bedrock or the foundation of what we're going to talk about today is intellectual property, or IP. And so essentially, what is intellectual property? It's anything that's intangible that gives you some competitive advantage or legal protection or value in your business. So think of IP as an intangible property right. So tangible property would be furniture, fixtures, or equipment, something you could feel or touch, right? Intangibles are things that you can't feel or touch, but it's essentially property of information or creations or inventions or goodwill. That is what IP is. And it's oftentimes the most valuable asset of your business. It helps differentiate you between you and a competitor, and it creates competitive advantage for you in the marketplace. So examples of IP might be some of your trademarks, proprietary methodology, your training materials, your forms and templates, your vendor lists, or your supplier information. So all of these things, these sources of information, these shortcuts of goodwill, the things that you've cultivated, written, or developed are all valuable IP to your business. Next slide. So why IP matters in county contracting is the first thing that you should do is inventory what is your IP, because there will be provisions in the county contracts that essentially identify things like deliverables or ownership rights of intellectual property created throughout the term of the contract. So failure to address IP issues in county contracts might mean that you just gave rights to your intangible property or your or those things that give you competitive advantage. So what you want to do is think about IP in county contracting, this valuable intangible that comes from information rights or creations or goodwill, and then thinking about how you're protecting it and what you're giving away. So let's talk about intellectual property on a deeper level. So the first, next slide. Next slide. Next slide. The first form of IP that a lot of you might have encountered are trademarks, right? You've heard it a lot, you've seen it a lot, and you probably wondered about what it is. So think about a trademark as a mental shortcut. That means someone's ability to identify the source of the goods or services by looking at a logo or seeing a name or seeing a slogan. It helps distinguish your goods and services from those offered by your competitors. So on the bottom right-hand side of the slide, you'll see examples of trademarks, right? These are all logos of some brands you might have interacted with. So trademark protection extends to a specific category or class, right? So for example, the mermaid extends to the category of class for Starbucks for a coffee, right? Coffee drinks. You see the mermaid with the green and white logo, and automatically you say, okay, I know what the source of those goods are or services, and that's going to be Starbucks, right? Same thing with the golden arches and McDonald's. The moment you see the golden arches, right away you think McDonald's. So in your mind, there's a mental shortcut. What the menu entails, how the look and feel of a McDonald's store might be. So think about logos or names as protections over certain classes or categories. So for example, the golden arches for restaurant services, the mermaid for coffee, coffee shops and coffee. So think about those as mental shortcuts to help you identify a particular source of the goods and services. Next slide. So you can get trademark protection in two ways, via what's called common law rights, and then via the United States Patent and Trademark Office, which is registered rights. So I'll kind of explain that plain English and flesh it out. So if you don't register your trademark, like your logo, your slogan, your name, you have what's called common law rights. So if you don't register those rights with the United States Patent and Trademark Office, you have common law rights. Those rights stem from your direct geographic area, right? So might stem to Chicago or Illinois. When you register your trademark with the United States Patent and Trademark Office, you have what's called federal rights, okay? So that means you've put everyone on constructive notice nationally that you own that name, that logo for a particular set of goods and or services, right? Depending on how you, what mark you've applied for. So you want to register your trademark because it gives you certain rights, right? And those certain rights are stemming from a statute called the Lanham Act. It says if you prevail in a likelihood of consumer confusion action, you're allowed to get your attorney's fees and treble damages if you prevail, right? So registering your trademark with the United States Patent and Trademark Office allows you to get what's called federal registration. It gives you the benefit of the statute, plus it puts people on notice that you're using that mark nationally. I highly recommend that if you are using a name, a logo, or a slogan, that you seek federal registration, right? And so you would put an application on file with the USPTO or the United States Patent and Trademark Office for a mark that you're using or you intend to use. And since this is an hour presentation, I'm trying to only focus on very important aspects of registration, but without delving too much into the weeds. So this is more of a survey sort of discussion, right? Versus like intimately going into trademarks. So once you file an application with the United States Patent and Trademark Office, that could take 8 months to a year for your application to be prosecuted by a United States Patent and Trademark Office attorney or an examiner. And so you essentially, before you put the application on file, you should search for your name, your logo, or your slogan. So you should work with an attorney to do a search to make sure that your name is not infringing on anyone else's name, or your logo doesn't infringe, or your slogan doesn't infringe. And once you clear that search with your attorney, you'll put an application on file. That application is assigned to an examiner or an attorney at the United States Patent and Trademark Office. And if they clear it for registration, it proceeds to publication, in which case, the general public has 30 days to oppose the mark. And if no one opposes it, then it proceeds to registration, and you get the trademark certificate from the USPTO, and then you can use the R with the circle around it. That's really a very truncated discussion of the whole trademark process. But the one thing you should take from the discussion is you should always seek to register your marks, because again, it expands your territory, especially if you're doing business on the World Wide Web, right? And it gives you the benefits of the Lanham Act, the statute that gives you the sword if someone tries to infringe on your trademark. And it also forces you to think about registration in a way that you're trying to protect your brand or your goodwill that you've cultivated in the marketplace. Next slide. So if you don't decide to register with the USPTO, at minimum, you should register your trademark with the Illinois Secretary of State, which essentially pegs the date of first use of your mark. So definitely do one or the other, and depending on how much resources you have, again, is strongly encourage federal protection. And then after you register your mark, it's not enough that you registered it, but you should enlist watchdog services like IP watchdog services to monitor the mark in the marketplace, because that essentially identifies any unauthorized use of your trademark, or potential infringement that you can address right away so that someone doesn't capitalize on the goodwill that you've created in the marketplace, right? Or if there's not a fake website selling your services or similar services. And so the law will only seek to protect you and continue to protect you if you monitor, police, and enforce your rights. Okay, so that's a general synopsis of trademarks. The next way to protect your valuable information or some recipes that you've created or some of the things that you've done is through trade secrets. And that's a little bit different than trademarks. With trademarks, you're going to register them again with the USPTO. With trade secrets, it's next slide. It's information that gives you value, but you keep it secret, right? So think about Coca-Cola and the recipe for KFC, both of which are secret. So think about a business whose competitive advantage is some, sort of secrets, methodology, recipes. So trade secrets can't be registered with a government agency. It's the business owner essentially taking very concerted steps to keep the information secret, right? So think about client lists, recipes, methods, reports, concepts. So what have you done to keep it secret? So ways that you would keep something secret, because if someone were to steal a trade secret, like an employee or a competitor, you have to demonstrate this concept of keeping things secret. So here's ways to do that. Next slide. So you could limit the pool of people that know about the information. So specific employees only have access to the information. The information is password protected. There's trade secret or confidential written on the information, and you're monitoring access to it. Everyone that has access to the information needs to sign non-disclosure agreements. There should be non-disclosure provisions and confidentiality provisions in employment agreements, identifying the trade secrets and limiting employees from disclosing that information. And so again, employment agreements, NDAs, anything that prohibits you keeping it secret, password protected information, a limited pool of people get access to it. So that's one way to protect very sensitive, competitive information. So that's another thing you have to think about. The third thing that you've probably encountered is a copyright. Next slide. And so copyrights protect original works that are fixed in a tangible medium, right? Or expression. Again, fixed to something, right? Think about photographs. Think about artwork that's been created. Think about a book. A lot of times training manuals. So you can't protect ideas, right? There's no protection for ideas. It's the original expression of that idea fixed in a tangible medium. So think about, anything that's fixed, written, photographs, painted, performed and recorded. So anything that's fixed is copyright protectable. It also has to be an original work. Protection on copyrights is 70 years plus the life of the author if it's work that's created by you, right? So you plus the life of you plus 70 years. And then if anything is created, for example, by your employees and there's work made for hire provisions in the employment contract, those last for 95 years from the first publication or 120 years from the creation, whichever expires first. So you register copyrights with the US Copyright Office. Next slide. And so applications are submitted for the date that the work is created. Like trademarks, the process takes several months. And then if you don't register the work right with the United States Copyright Office, you have what's called a common law copyright. Again, there's more limited legal remedies and more enforcement for common law rights. The statute, the U.S. Copyright Act, gives the U.S. copyright holder many benefits, including statutory damages and attorney's fees, versus common law rights, which are very thin and then require the enforcer to incur their own fees and expenses. And then it's hard to determine what the true damages are versus the statute assigning some of those damages. So when you're a creator and you create a copyright or an original work fixed in a tangible medium, you have the right to reproduce the work, the right to distribute it, display it, or create derivative works from it. Next slide. Before that. So again, recommendation for all of you guys, if you have training manuals, photographs, anything that is fixed in a tangible medium, make sure that you're getting registration through the United States Copyright Office. Make sure that to mark your works, with the C, with a circle around it, and give public notice of your rights. And then if you're letting other people use your copyrights or your trademarks or any sort of your intellectual property, make sure that there are licensing agreements in place that lay stake to your IP, and then allow that person to license that intellectual property from you in accordance to terms set forth in your licensing agreement. So how do you ensure that these forms, and this was just a very sampling of common forms of intellectual property that business owners see in county contracts, how do you ensure that, that they're protected in county contracts, whether you're a prime or you're a subcontractor? Next slide. So who owns the IP and who owns the deliverable, right? So the county frequently requires, either a sub or prime to give some license to the IP. So remember, you own the IP, right? Depending on what you're doing. And then the county owns the deliverables, right? You're using your intellectual property, whatever it is, to create deliverables for the county. So depending on what IP the county is essentially licensing, right? They want rights in the final product, but you want to retain rights in the underlying intellectual property. So where you're looking at is really looking at the language to ensure that the intellectual property provision addresses the underlying IP and the deliverables and distinguishes between who owns what, right? And then when you create work product for the county, there should be, you'll see what's called the work made for hire provision. Next slide. So sometimes you'll see that in contracts with the county, but more importantly is if you have employees working for you to facilitate county contracts, and those contracts require the creation of IP and the deliverables, you want to make sure that your underlying contracts with your independent contractors or your employees have a work made for hire provision that assigns those rights to you, so that way you could essentially assign those rights to the county, right? So if your employees or your independent contractors are making, are creating IP, and that IP is essentially the deliverable, you want to make sure that there's some transfer of ownership. So that way, when you're making a representation to the county, that the deliverables are its deliverables, that the underlying contracts address these things. Next slide, please. So not every deliverable will qualify as a valid work made for hire. So there should be some IP provision in your underlying contracts with your employees that assigns any and all rights, title, and interest by that employee to you. And then depending on what your agreement is with a prime or what the prime's agreement is with the county, those provisions have to address assignment of the intellectual property so that what the county has paid for is what it's gotten, and what you retain is clearly set forth in the agreement. So it's really important in the chain of title, right? From your employee, independent contractor to a subcontractor, to a subcontractor to the prime, then to the county, that there's a clear chain of title of where the IP is coming and what IP is restricted or owned by that party. So that's a really important provision. So think about it from flowing of the ownership rights. Next slide. So prime to county, subcontractor to prime, employees and independent contractor to subcontractor or prime. So each time there's a flow of ownership rights, we have to ensure that there is a proper agreement or provision in place to make sure that if we're making a representation in the next contract, that there is a chain of title and we know that that IP has been assigned, or there's a work made for hire provision or whatnot to ensure that there's a clear chain of ownership from contract to contractor. So one missing assignment or one missing paragraph can impair the final trail to the county. So make sure you have an attorney review your contracts to ensure that you are compliant and that you have done this in a correct manner, because it will get confusing. Next slide. I think we're on the, okay. And then what if a third party IP is used? Make sure that if it's IP that you're using from a third party, right? You didn't create it, your employee didn't create it, your independent contractor didn't create it, that you have rights to that IP, right? And that you could either sublicense it to the county or sublicense it to a prime. So again, why it's important to identify what's yours and what's not yours. Then you know, do I need an assignment? Do I need a work made for hire provision? Because I'm going to need to own whatever I'm licensing or assigning before I enter into a definitive agreement. Next slide. So again, protecting your existing intellectual property is understanding what you own prior to any sort of contracts, right? And then how do you transfer ownership, right? What to the deliverables, what pre-existing IP will remain with you, right? There has to be a definition for that. And what rights are necessary for the county to use the deliverables. Next slide. Next slide. So what is confidential information, right? You'll see that also a provision in the agreements, right? So information that's not publicly available is confidential. I can't Google it. I can't find it. It's anything that provides value to your organization, right? And then how do others treat it when they're privy to it, right? So think about your customer, your client list, your supplier, your financial information, bids or proposals, right? That include some proprietary information and non-public county information. Either you're going to give it or you're going to get it. So you have to understand what it means. And usually there's a provision in the agreement that defines what confidential information is, right? In your contract with a prime or your contract with the county. So you want to look to see what that definition entails. And then what is not confidential information is also defined in the agreement. So some things that could qualify as not confidential information, next slide, could be information that's not publicly available. Information that's independently, not independently developed, right? Information that you receive from a third party, or information that could be authorized for public release or that is publicly released. And then think about confidential information as, again, a form of IP. It's a property right, right? A right in the information, right? Because it gives competitive advantage. It's very hard to fathom as a layperson, but think about it as a property right. And that's the intellectual property right value in information. So next slide. So confidential information, just like a trademark or a copyright, is also a valuable business asset. It gives competitive advantage. It can save significant time and expense if someone were to gain access to it. And it's sometimes even more valuable than physical assets. So special considerations that you should take, next slide, when dealing with the county's confidential information is whether or not there's a data breach, right? Whether or not someone gains access to your servers. Do you have cybersecurity insurance? What if someone gains access to certain information while you're performing a county contract and then uses this information to create harm to the general public or to result in financial damages to people? So you have to think about that information and what the county requires for you to protect it, depending on what services you're providing the county. Okay. Next slide. So what you should think about is, what standard of care or level of care do you use to protect your own information? And some of those same things are going to be required by the county, if not more, right? So it might be in the form of insurance policies. It might be in the form of really strictly drafted confidential provisions. It might be in the form of who gets the access to the confidential information. And it might be in the form of, once you get access to it, what would you do to destroy it after you perform work for the county? Next slide. So things that you should do to ensure that you're compliant with your county contract and you're protecting the county's information are those confidentiality provisions that we talked about earlier today, right? In your employment, independent contractor agreements, in the subcontractor agreements, in the prime agreements, the password protection that we talked about, even though it was in the context of the trade secret conversation. And then, ways that you mark documents or conversations that you have with employees or NDAs that you should have your vendors, your independent contractors, your employees sign. So which gets us into the discussion, next slide, that every single business needs to have a standard NDA. So if you don't have one, best practices are you talk to your attorney and you make sure that you draft one. And why that's really key is if you're doing any sort of business with anyone nowadays, because we're in the information age, you're going to need to protect yourself. And more importantly, the people working with you need to know that if they disclose certain things to you, like proprietary pricing information, their trade secrets, that you and your employees and your independent contractors are going to keep that information secret. So it provides remedies in your agreement, your NDA, if the information is improperly disclosed, who gets access to the information. It also creates a contractual obligation for anyone to protect confidential information, whether it's your information or information that you need to protect on behalf of someone else, in this case, the county. So practical steps to maintain confidentiality that you should employ when in the context of county contracts. Next slide. Label all documents confidential. Limit access to confidential information on a need-to-know basis, right? Not everyone in your organization should have access to the information. Train your employees and your subcontractors on confidentiality obligations. Have them sign confidentiality agreements, right? And make sure in your employment agreements and your independent contractor agreements that you have confidentiality provisions, and then promptly address any unauthorized disclosures, right? So if you find someone breached, you have to promptly discuss, make sure that you address that issue, okay? So that's a sampling of things that we have to think about in terms of like intellectual property, confidentiality obligations, identifying what intangible assets are competitive advantages to our business and learning how to protect them. And then understanding that in the context of contracting with the county, that the county has confidential information and the county will require you to protect its information because it also has value in that information. And so depending on what services you're providing the county, it's very important to sit down with your attorney, talk to him or her about what IP assets you are, what protections you have in place, and what sort of contracting you're going to do with the county, and whether those whether you're contracting, whether you're a prime or a subcontractor, what you can do to maintain your confidentiality obligations, and what belts and suspenders you have in place in the instance that there's unauthorized disclosure. So that's the first half. Now we're going to look at operational and compliance risk management. Next slide. So risk management starts really before a problem arises. So effective risk management, right, or contract disputes usually stem around compliance issues, right? Did you comply with the terms of the contract, or are you aware of certain rules, regulations, or statutes that are governing the work? And have you identified the risks before you began the work or submitted a proposal? That's the first thing. Again, inventory, right? And then if something happens, the best safety net usually is insurance, right? So look at next slide. I know a lot of you have insurance policies that you haven't read. And you think that once you have insurance, that's an end all be all. That is not the way to approach county contracts or contracts generally. You need to make sure that you have a meeting with your broker at least on a yearly basis to go over your policies, to ensure that you have adequate protection and to better understand your coverages. If you don't do that, you might have certain policies expire, policies lapse, or you might not be adequately covered for the type of projects or work that you're doing. So make sure that you have a really solid discussion with your insurance broker, again, to talk to you about what insurance you're maintaining and whether that insurance is adequate for the types of contracts that you're doing, right? And the business that you're doing. And then make sure you maintain copies of all of your certificates of insurance and your insurance binders. So common insurance requirements in county contracts look like this. Next slide. Commercial general liability, employee practices, automobile liability. I'm not going to read off the slide, but make sure you look at the insurance requirements in your contracts and talk to your broker to make sure that you are compliant and that your insurance requirements for the type of projects that you're doing are adequate and in compliance with the contract, meaning this is what the county wants, this is what you should get. Now, the insurance requirements in county contracts may be able, next slide, to be negotiated based on what goods or services you're providing. So let's say, for example, you're doing an event and all you're doing, I'm making this up, is providing balloons at the event, right? You're a balloon purveyor and all you're doing is providing balloons. And if there is, I'm making this up, a $5 million cybersecurity policy in the county contract or in the subcontractor's agreement with the prime, then if you're a balloon provider and you're not touching any sort of technology, then that might be a policy that you don't need to carry. The point being is talk to your insurance broker about the insurance provisions that are required and then see if those limits could be negotiable based on the goods or services that you're providing. And then remember, if you don't have adequate insurance and you're not maintaining it per the terms of your agreement, then you're not in compliance with the contract and you're in default. So again, understand what you have, understand what's required, and then see if there is some ability to negotiate. And, if you're a prime contractor on a county project and you enlist the services of a subcontractor, next slide. So make sure that, again, there's some flow down provisions to the subcontractor to manage the risk, and to mimic the provisions, the insurance provisions in the county contract, right? So you want to make sure that the insurance risk, because you as the prime are responsible, is also flowing down to the subcontractor so that both of you are in compliance with the county contract and that you're able to do the job, and that if there's any sort of requirements that the county has to be named as an additional insured, it should be on the prime and the subcontractor agreements, right? And sometimes you're going to have to notify of cancellations or material changes on the insurance carrier has to on and note so on the certificate. So make sure, again, you're looking at the insurance provisions, you're discussing them with your broker or your agent, and then you're making sure that there are flow down provisions, again, just like the IP. Every step of the contract, there has to be continuity in what the agreements are going to what the agreement is with respect to insurance, right? And then maintaining the proper permits and licenses to do the work, right? Next slide. That's also a compliance issue. And again, you have to have the necessary licenses and permits, and your license can't, for example, have expired. You have to track all license and renewal dates, just like you would track insurance policies. And then you have to make sure that if you're hiring a subcontractor, to do the work under the agreement with the county, that they also maintain the required licenses and furnish copies of the permits and licenses that are required to do the work, right? And then you want to ensure compliance with applicable laws and provisions. So if there's certain statutes that you have to comply by, next slide, like, wage and hour laws, labor laws, any sort of ethics rules, conflict of interest, data privacy, record keeping requirements that we've talked about in previous sessions, or equal opportunity requirements, that you are doing that and that you're making sure that your subcontractor is doing that. Because again, if you don't do that, then you're in breach of the agreement. And then we talked about this in previous presentations. Next slide, the record keeping requirements. Again, keeping documentation and records is really, really important. So make sure that if you do get a county contract, that you and the sub are maintaining records in compliance with how many years the county requires you to keep the records. Because again, all contracts are subject to FOIA. And so if the county requires you to produce information or whatnot, that we have access to that information. And then, restrictive covenants and protecting business relationships are other things that we think about when we're thinking about risk management. So next slide. Next slide. Restrictive covenants usually limit or restrict certain acts or certain acts. So whether it's soliciting, competing, sharing confidential information, that's really key. And so you want to inventory, right, in order to protect a relationship, what you can and cannot do during the term and after the term of the contract. So this helps prevent misuse of confidential information or risks losing key employees, right? What are the restrictive covenants that are imposed by a prime on a sub, or the county on a prime and a sub, right? So common types of restrictive covenants are like non-solicitation, next slide, of employees, non-solicitation of customers, and they help protect like investment in people and clients, or they protect their legitimate business interest, right? Remember, your people, your information, your clients, those are all sources of value, or like in IP, right? They're intangibles. So why restrictive covenants matter is they're protecting a legitimate business interest. And like we said, next slide, that can come in the form of a non-solicit of customers or employees, not to circumvent an agreement or confidentiality agreements, right? Restrict disclosures, right? So anything that restricts, because it's protecting a legitimate business interest. So with non-solicitations of employees, next slide, you don't want to lose key personnel, right? And that those key personnel risk, risk a legitimate business interest, right? Either someone recruiting or hiring your employee and then cutting you out as the middleman, so to speak, or you're required to have specialized personnel, right, under certain county contracts. So you want to make sure that there are restrictive covenants, maybe in employment agreements. So again, to restrict disclosure of confidential information, or to stop a competitor from taking your key personnel. And then there are non-solicitation agreements. Next slide. Ways to like limit or best practices for non-solicitation agreements. Sorry, am I over? might be, ensuring that there's a legitimate business interest, and then clearly identifying what employees are being protected. And then we could skip this slide, next slide, because we're running out of time, and I apologize about that. Again, non-solicitation for business and customer business relationships, again, to restrict the relationships connected to the project, because again, there's a legitimate business interest. And then including a reasonable time limitation on these are best to make sure that they're enforceable. And then identifying problems early is, again, inventory, identify problems early, make sure your contracts address those. And then next slide. And then next slide after that. Next slide, because we're running out of time. I apologize, we're running out of time, and I want to cover the last thing. So when a dispute arises, next slide, you want to make sure that, whether it's scope of work, late payments, these IP disputes, right? Someone stole something from you or didn't comply with a restrictive covenant. Always explore potential resolutions before just running to the courtroom and filing litigation. Seek like a mediator or mediation, or make sure that's in your agreements, because litigation is costly, time intensive, and takes away from your business. So again, think about the dispute, consult your attorney, and find if the dispute is, next slide, worth next slide, worth pursuing. And then next slide, sorry, next slide, next slide, next slide, sorry. If the dispute is worth pursuing, whether it could be negotiated, corrected, or whether there's an alternative dispute resolution before litigation, because ultimately that would mean that you, the county, and the prime and the subcontractor might be in litigation. So with I know we went a little bit over. I kind of was a little bit ambitious on this topic, so we didn't essentially cover all of this, but you will get a copy of the slide deck, and you're more than welcome to reach out to me with additional questions. I always leave my contact information at the end. So Sabrina, if you could move it to the next slide. Next. There's my contact information, so you're welcome to contact me with any sort of questions that you might have. I'm more than happy to answer them. Use my email. That's the best way to reach me. And I wish you all the best of luck, and I hope that you have very lucrative contracts that help you jettison your business and do great things. So I guess that's it. And Sabrina, if you want me to answer any questions, I'm happy to do it, and stick around for a little bit if people want their questions answered. No problem.
Okay, well, thank you so much, Lemma. And we definitely were not rushing you. This is your third webinar in the 4-part series. And each time you come, you bring a wealth of information, a lot of slides, and we always get a lot of questions. So I just wanted to make sure that people started dropping their questions in. So when you were done, we could just go right into the Q&A. Anyway, again, if anyone has questions that you want to ask Lemma while we have her on the line, please drop them in the chat. Also, just to reiterate, we will be sharing the deck after this presentation. So any questions, please drop them in the chat. We have about 3 minutes. Lemma, again, thank you.
Thank you so much, Sabrina.
Of course. We have really enjoyed having you here. As I mentioned, this is our 4-part series. This is part 3. Anyone who has enjoyed today's information, as I said, the first and the second webinar were chock full of information as well. We have one left. on Tuesday, November 10th. Lemma will be coming back for her final webinar, and this is Building Success for Veteran Entrepreneurs. Again, that's Tuesday, November 10th, same time at 12 o'clock. So we're looking forward to that. If you missed the webinars 1 and 2, please try to make it back for 4. Again, Lemma, thank you so much.
No problem. It's my pleasure.
And I don't see any questions in the chat. We have a lot of thank yous. And then we have also just dropped the link. So anyone who is on this call can register for the veterans webinar that's going to be on November the 10th, Navigating Cook County Contracts, Building Success for Veteran Entrepreneurs. So the link has just been dropped in the chat for that. And again, we will be sharing today's deck.
Thank you so much, Sabrina. I really appreciate it. And good luck to everybody.
All right. Well, thank you very much. And we will see you on November 10th.
Great. Have a great day
You
and
too.
a great
Bye-bye.
weekend. Thank you.